If this was useful, there's a lot more where it came from. Other specific situations, other specific rights, all covered with the same care we're putting into today's topic. Subscribing is the easiest way to make sure you don't miss the next one, especially since a lot of these topics tend to become relevant exactly when you least expect it, which is exactly why it's worth having them ready in advance rather than scrambling to look them up in the moment. All right, let's keep going with today's topic. There's a knock at your door. Not a ring, not a buzz, not the light tap of a neighbor borrowing something. A knock. Firm, deliberate, evenly spaced, the kind of knock that lands differently than the others you hear through a normal day. You move toward the door, you look through the peephole, and you see a badge. You see a uniform, and in that exact fraction of a second, before you've said anything, before you've even touched the doorknob, before you've even fully registered what you're looking at, you are already at the most legally consequential moment of your entire interaction with that officer. Not when you speak, not when you open the door. Right now, in this second, before any of that has happened at all. And the reason that moment matters so much, the reason I want to spend this entire video sitting in it with you, walking through it carefully and completely, is that most people handle it wrong. Not because they're careless, not because they don't care about their rights, but because nobody ever actually explained to them, clearly and completely, what their front door means in the legal framework of this country, what it actually represents, what it actually protects, and exactly what happens to that protection the moment they make a single uninformed decision about whether and how to open it. Here's what I want you to walk away from this video knowing, cold, without needing to think about it, without needing to look it up, without needing to piece it together from memory, while someone is standing on your porch waiting for you to do something. Your home is the single most legally protected space in your entire life. More protected than your car, more protected than your workplace, more protected than any public sidewalk or park or street corner you could possibly be standing on. The Fourth Amendment protection against unreasonable searches and seizures reaches its absolute peak the moment you step inside your own front door and closes it behind you, and courts in this country have been saying that, consistently, emphatically, for longer than almost any other legal principle you're likely to encounter. That protection exists right now. It exists for you, specifically, whether you own your home or rent it, whether it's a house on a quiet street or a unit in a large apartment complex, whether the officers outside came in marked cars or an unmarked sedan that's been sitting down the block. The wall is there. Your job is to understand it well enough to not accidentally take it apart one small, seemingly harmless decision at a time. If you want to actually know your rights before you need them, instead of guessing at the worst possible moment, subscribe right now, because that is exactly what this video and every video on this channel is built to give you. And a quick note before we go further, everything covered here is legal education and general commentary, not legal advice tailored to your specific situation, and some of the specific details shift from state to state. But the core principles, the ones that matter most, the ones that should be living in your head before you ever hear that knock, hold up almost everywhere in this country. Let's get into it. Let's start with the single most important legal reality underpinning everything else we're going to cover, the one fact that changes how every other rule in this video gets applied. Your home sits at the absolute peak of Fourth Amendment protection. The Fourth Amendment protects against unreasonable searches and seizures by the government, and when we say your home is where that protection is strongest, we mean it quite literally. I want to be upfront about something, because I think it's important to say directly, rather than bury in a quick disclaimer. General legal education, including everything we do here, has real limits, and it's worth understanding exactly where those limits are. What we can do here is give you a strong, accurate, genuinely useful foundation, the kind of understanding that changes how you experience a real situation when it happens. What we can't do here is account for every specific variation, every local nuance, every unique detail of your particular circumstances, because that's simply not something general content is built to do, no matter how thorough it tries to be. That's exactly why the foundation matters so much, though. A strong general understanding is what tells you when a situation is straightforward enough to handle with what you already know, and when it's specific and serious enough that it's worth bringing in someone who can look at your exact circumstances directly. All right, keeping that framing in mind, let's get into it. Literally. Courts have returned to this principle over and over, in case after case, across generations of legal interpretation, and the message has stayed remarkably consistent. The home is different. The threshold of your front door is not just a physical line, it's a legal one, and what's on the inside of that line carries protections that almost nowhere else in your life can claim. The framers of the Constitution built this protection deliberately, with full awareness of what they were doing and why. They had lived through a world where government officials entered homes whenever they decided they wanted to, searched through belongings without justification, and left ordinary people with no recourse at all. The Fourth Amendment was built as a direct, specific response to exactly that experience, and the courts have understood and honored that intent consistently, treating the home as the one place in American life where the government's ability to intrude without proper authorization reaches its most difficult, most demanding legal hurdle. That's what you have. That's what you're standing on the other side of when you hear that knock. Now let's talk about what that actually means for the very first thing you should do, or more precisely, the very first decision you're allowed to make, which is this. You are not required to open your door, not just under some circumstances, not just if you have a good enough reason. Under the overwhelming majority of situations you will ever actually face, you have no legal obligation to open your front door simply because someone is knocking on it. Not a police officer, not anyone. The knock itself creates no duty. It's exactly like a ringing phone. The ring doesn't oblige you to pick it up, and the knock doesn't oblige you to open the door. You can look through the peephole, see the badge, see the uniform, understand completely what's happening, and still make the decision to simply not engage at all, and that decision is not illegal, does not constitute obstruction, and is not evidence of guilt, wrongdoing, or anything else. I understand that this feels wrong to a lot of people. It cuts against an instinct that runs deep, one that says a uniformed officer at the door creates an obligation, that the polite and law-abiding thing to do is to answer and cooperate, that only someone with something to hide would keep their door closed. I understand that instinct. I also want you to understand that it's legally backwards, and that acting on it without thinking has caused real, serious, entirely preventable harm to people who had absolutely nothing to hide but simply didn't know their rights. So let's walk through what you should actually do, in sequence, from the moment you hear that knock, because the order matters and the details within each step matter. First, don't rush and don't panic. I know that sounds obvious, but it isn't, because the immediate physiological response to an unexpected firm knock when you weren't expecting anyone is a stress response, and a stress response pushes you toward action before thought. Resist it. Take a breath. Move toward the door at a normal pace, look through the peephole or a window, and simply gather information before you make any other decision at all. How many people are there? What are they wearing? Are there marked or unmarked vehicles visible? This isn't about stalling or being dramatic. It's about making sure you have some basic situational awareness before you engage with anything at all. Second, understand that you can speak through the door without opening it, and in most situations, doing exactly that is the choice that preserves the most protection for you throughout everything that follows. You don't have to open a window or crack the door or step outside. A clear, firm voice through a closed door communicates perfectly well, and keeping the door closed throughout the entire encounter is a completely legitimate choice, one that doesn't hurt you legally in any way and often protects you significantly. Third, and this is the move that does more to clarify and shape the entire situation than anything else you could possibly say or ask, the very first words out of your mouth should be a simple question: do you have a warrant? 4 words. That question immediately establishes 2 things simultaneously. It establishes that you know the relevant legal framework, and it forces the encounter into one of 2 clearly defined paths based on the honest answer to that question, because those 2 paths lead to genuinely different places. Let's walk through both paths completely, because understanding exactly where each one leads is what this whole video is built around. If the answer is no, meaning no warrant, they're there for a knock and talk, they want to ask some questions, they're following up on something, they just want to chat, then the entire encounter from that point forward is, in legal terms, a voluntary consensual interaction, and voluntary means you get to decide how much of it you actually participate in. No warrant means no authority to enter your home without your permission. No warrant means no obligation on your part to answer questions. No warrant means no obligation to open your door. The whole thing is, from your side, completely optional. What you can say, through the closed door, calmly and without hostility, is something like this: I appreciate you stopping by, but I don't consent to you entering my home. If there's something specific you need to communicate, I'm happy to talk through the door for a moment, but I don't have questions I'd like to answer right now. If you'd like to leave contact information, I can reach out if needed. That is a complete, respectful, Legally sound response. It doesn't invite confrontation, it doesn't suggest you have something to hide, and it preserves every single protection your home offers you. Now, officers conducting a knock and talk are generally trained to continue the conversation even in the face of initial resistance, because they understand that some people will change their minds, will open the door, will start talking, if the pressure stays on gently and persistently for long enough. You may hear things like, "We're just trying to clear something up," or "This will only take 2 minutes," or "We're not here to cause you any trouble," or even, "If you've got nothing to hide, you've got nothing to worry about." None of these statements change the underlying legal situation. None of them create an obligation where one didn't exist before. The right response to any of them is a calm, polite, consistent repetition of what you've already said. "I understand, but I still don't consent to entry, and I'd rather not answer questions right now." You're allowed to say this multiple times. You're allowed to say it as many times as it needs to be said. Firmness and repetition in this situation are not rudeness. They are exactly what the situation calls for. If they tell you that refusing to cooperate makes you look suspicious, you can simply acknowledge the statement without accepting its premise. "I understand that's how it might look, but I still don't consent to entry, and I'd prefer not to answer questions right now." You're not arguing with them about whether you look suspicious. You're simply continuing to assert what is entirely yours to assert. Now let's go down the other path, the one where the answer to "Do you have a warrant?" is yes. This is where people get into real trouble, not because they resist the warrant, that's a different problem, but because they don't actually read it, don't understand what kind it is, and don't understand what it actually authorizes, all of which leaves them in a far weaker position than they need to be. Because not all warrants are the same kind of warrant, and the difference matters enormously. When officers say they have a warrant, before you do or agree to anything, you ask them to hold it up to a window or slide it under the door so you can read it yourself. This is a completely reasonable request. It is not obstruction, it is not delay for the sake of delay. It is simply gathering the information you need to understand what you are actually being faced with, because you cannot make informed decisions about your own home and your own rights based on a verbal claim about what a piece of paper says. You need to see the paper. There are two fundamentally different types of warrants you might see, and the distinction between them changes what the warrant actually authorizes, which means it changes what you're required to allow and what you're still entitled to refuse. The first type is a search warrant. A search warrant is an order signed by a judge based on a sworn statement establishing probable cause, authorizing officers to search a specific location for specific items. A valid search warrant for your address signed by a judge specifying your location, describing with reasonable specificity what's being searched for and where officers are authorized to look. That document does give officers legal authority to enter your home, over your objection if necessary, because a neutral judicial officer has already reviewed the evidence and made the determination that entry is legally justified. If you are shown what appears to be a valid search warrant for your address, you should not physically block entry or interfere with its execution. Doing so creates serious legal exposure for you that is entirely separate from and potentially far worse than whatever the warrant itself is about. What you should do, and what you absolutely should do without fail, is state clearly and audibly, for the record, exactly this: "I do not consent to this search, but I understand you have a warrant and I will not physically interfere with its execution." That sentence matters more than it might sound like it does. Saying it creates a clear, documented record that your consent was never given, which means that everything that happens during that search happened under the authority of the warrant, which in turn means that if the warrant had any defects, if it was obtained improperly, if it was executed in ways that exceeded its stated scope, any evidence obtained can potentially be challenged on those grounds. Your statement isn't defiance, it's preservation. It's protecting the foundation of a legal challenge that might matter enormously later, in a setting properly built for examining it, with a lawyer who knows what they're doing. Let's talk about what makes a search warrant valid, because this matters if you ever find yourself trying to evaluate one through a window in real time. A valid search warrant needs to be signed by an actual judge or magistrate, not just filled out by an officer. It needs to name or specifically describe the place to be searched, meaning your actual address, not a vague reference to the general area. It needs to describe the things to be seized with reasonable specificity, so that officers aren't given essentially unlimited authority to search through everything you own, on the strength of a warrant that says almost nothing. It needs to be executed within the time frame stated in the warrant, and it needs to stay within its stated boundaries. meaning officers searching for a specific item in a specific location don't have blanket authority to search every part of your home simply because they're physically inside. If you look at a warrant through a window and something looks wrong, it's for a different address, there's no visible judge's signature, it appears to have expired, it looks obviously incomplete in some way, you can say so, calmly and specifically. This appears to be for a different address, or I don't see a judge's signature on this, or this looks like it may have expired, are not accusations, not arguments, and not obstruction. They are factual observations about a document that has enormous legal significance for your home and your rights, and making those observations out loud creates a record of what you noticed that an attorney can examine properly afterward. You are not trying to win a legal debate on your doorstep. You are simply making sure that the problem, if one exists somewhere other than just your own memory of the event. Now let's talk about the second type of warrant, because the differences here are real, and they catch people completely off guard. An arrest warrant is fundamentally different from a search warrant. An arrest warrant authorizes officers to arrest a specific, named individual. It is not, in itself, authorization to conduct a full search of your home. The authority an arrest warrant conveys is much narrower. It authorizes the arrest of the person named in it, and it may authorize entry into a residence where there is reason to believe that specific person is inside, for the specific purpose of locating and arresting them. But an arrest warrant does not generally authorize a broad search of your home, a sweep through your belongings, a look through rooms unrelated to locating the named individual. If officers show you an arrest warrant rather than a search warrant, the right response is to look at it, identify that it is an arrest warrant, and then state clearly, I can see this is an arrest warrant. I don't consent to a search of my home beyond what's specifically required to locate the named individual. End quote. This puts on the record, clearly, that any broader search that happens after that statement wasn't something you agreed to, regardless of what officers may later claim about why it was necessary. If the person named in the warrant is you, that is an entirely different situation with its own set of serious considerations, and you should say nothing beyond asserting your right to an attorney before saying or agreeing to anything further. Let's talk now about something that sits right at the edge of the warrant question, the place where things get messier and more contested, which is the category of exceptions to the warrant requirement that officers sometimes invoke at the door. The most significant of these is exigent circumstances, the idea that some emergencies are serious and immediate enough that requiring officers to stop and obtain a warrant before entering would defeat the entire purpose of responding to the emergency at all. Courts recognize this exception, and it applies to genuinely serious, immediate situations. Someone screaming inside the home, an active life-threatening emergency, a reasonable belief based on specific facts that evidence of a crime is being destroyed in real time. Things in that general category of genuine urgency. If officers claim exigent circumstances and move to enter your home over your objection, physically blocking them is not the move. For the same reason physically blocking a valid warrant's execution isn't the move. The risk you create for yourself in that moment is real, immediate, and largely irreversible. What you do instead is state clearly, I do not consent to entry, and then not physically interfere. Understanding that whether genuine exigent circumstances actually existed is exactly the kind of question that gets examined carefully, with full context and legal argument, in a courtroom, with an attorney, in proper proceedings built specifically for that purpose. This is actually one of the most actively contested areas of search and seizure law, precisely because the exigent circumstances exception is the one most susceptible to being stretched beyond its actual legal limits, and the appropriate place to challenge a stretch is in front of a judge, not at your doorstep in the middle of the night. Let's talk about the porch, because this particular physical space matters more legally than most people realize, and understanding exactly what happens when you step out onto it is worth your time. The interior of your home carries the strongest Fourth Amendment protection available. The moment you step outside, onto the porch, down the steps, out to the street, you are generally moving into a legally different space, and the protections that apply to you in that space, while still real and significant, are generally not as strong as the ones that apply to you on the inside of your own closed front door. Courts have analyzed this line in various ways in various cases, and the details shift, but the broad principle is consistent enough to be worth knowing and acting on. What this means practically is that if you want to preserve the maximum protection your home affords you throughout an encounter with police at your door, the answer is to stay inside and speak through the door, not to step out for a moment just to have a face-to-face conversation. I know this feels socially awkward. I know there's an instinct that says stepping outside to talk is the more cooperative, more normal, more human thing to do. But what feels socially normal and what is legally protective are sometimes genuinely different things, and this is one of those moments. Officers encounter this kind of interaction regularly and are trained to work within it. Staying inside and speaking through a closed door does not, in any meaningful sense, escalate the encounter or create ill will. It simply preserves something that belongs to you and is worth preserving. Let's talk about what to do when the encounter ends and officers leave, because this step gets skipped almost universally, and it matters far more than people expect. The moments immediately after an encounter like this one are when your memory is most accurate, when specific details are freshest, and when the information you capture is most reliable for any potential later use. Get out your phone and record a voice memo, or write down in notes everything you can recall in as much detail as you can manage. What time it was, how many officers were present, what they were wearing, including any visible badge numbers or nameplates, what was said, as close to verbatim as you can reconstruct it, whether any document was shown and exactly what it appeared to say, whether any claims were made about warrants, exigent circumstances, the purpose of the visit, whether anything was said about coming back, whether consent was asked for and what was said in response. This note-taking exercise costs you maybe 5 minutes, and its value is almost impossible to overstate. If anything about the encounter ever becomes legally relevant, a question about whether consent was voluntarily given, a dispute about whether a warrant was valid or properly executed, an inquiry into whether entry happened as described, the contemporaneous notes you made in the minutes immediately after, when memory was fresh and unaffected by later events, are genuinely valuable. They may be the closest thing to a real record of what actually happened that you ever have outside of camera footage, and they cost you nothing to create. Let's talk about recording the encounter itself, because this is worth addressing directly and completely. In most circumstances, in most places in this country, you are legally allowed to record your interactions with police at your own front door. A doorbell camera or smart lock camera that's already mounted and running automatically is doing exactly this work on your behalf, continuously, without requiring any active decision from you in a stressful moment. If you have one, it is arguably one of the most practically valuable tools you have for exactly this scenario, because it captures audio and video of what was said and what happened, creating an objective record that doesn't depend on anyone's memory, that can't be revised or recharacterized, and that an attorney can review with the same eyes you had in the moment. If you don't have one, and this video has you thinking about what you actually want at your front door, that's a reasonable thing to take from this. Recording actively, holding up a phone and making clear you're recording, is also generally allowed and is sometimes a useful thing to do, though it introduces its own dynamics into an already charged situation, and the decision is yours to make based on the specific circumstances you find yourself in. Let's talk about scenarios adjacent to the core situation, because several specific versions of this encounter are common enough and different enough from each other to be worth walking through individually, rather than assuming the same general approach covers all of them. Let's start with what happens when there's a knock, and it turns out to be about someone else entirely, a neighbor, a person officers believe may be connected to an investigation you know nothing about, a witness situation where you might have seen something. The exact same framework applies here. You are not required to let anyone in, not required to answer questions, and choosing not to is not evidence of anything, regardless of what you may or may not actually know. I don't have any information I'd like to share right now, but I appreciate you stopping by. Is a complete, polite, legally sound response that doesn't require you to be rude, doesn't suggest you're hiding anything, and preserves every protection that applies to you. The fact that an investigation doesn't involve you personally doesn't reduce your rights. It doesn't create a new category of obligation that replaces the general protections that exist for everyone at their own front door. Let's talk about welfare checks, because this version of the knock-at-the-door encounter has its own specific emotional weight and its own specific legal texture. Someone called and expressed concern about your safety. Officers show up to check on you. And the emotional dynamic of this situation, the fact that it's framed as concern rather than investigation, that refusing to engage might seem like you're rejecting care, that the people standing outside might genuinely believe they're helping, makes the pull to just open the door and show them you're fine feel almost overwhelming, in a way that a clearly investigative visit doesn't quite replicate. Here's what you need to understand about this specific scenario. If you are fine, you can communicate that through the closed door. "I'm okay, thank you for checking. I don't need anything right now," said clearly and calmly, resolves the overwhelming majority of welfare check situations completely and immediately, because the stated purpose of a welfare check is confirming someone's safety, and you've just confirmed it. If you can see and speak through the door with enough clarity that officers can reasonably assess that you are physically present and speaking coherently, you have accomplished what the check was designed to accomplish. If officers push for entry anyway, claiming continuing concern after you've clearly communicated that you are fine, the same principles apply that apply everywhere else. Genuine, specific evidence of an emergency, not a general unspecified sense of concern, is what justifies entry without consent under exigent circumstances. "I'm fine, I'm standing here talking to you, and I don't consent to entry," is a statement worth making and repeating, because it creates a clear record that whatever happens next, it wasn't something you agreed to, and the question of whether genuine necessity justified it belongs to the legal process rather than the doorstep conversation. Let's talk about Child Protective Services visits, because this version of an unexpected official knock at the door deserves particular care, and the emotional stakes involved make it worth treating with real seriousness rather than just lumping it in with the general framework. If a child welfare agency investigator shows up at your door, understand that in most places and under most circumstances, without a court order, you are not required to let them into your home, and you are generally not required to allow them to interview your children without your consent, though the specific rules vary more by state here than in almost any other area this video covers, and the stakes are high enough that understanding your specific state's rules in advance is worth real effort. What you can say, warmly and without hostility, is something like this: "I want to be cooperative, and I take this visit seriously. I'd like to understand specifically what prompted this visit, and I'd like to have an attorney involved before we proceed to any home inspection or interview. Can you give me contact information and a way to reach back out very soon?" This communicates genuine willingness to engage while preserving the ability to navigate a serious situation with proper guidance rather than purely on instinct in a moment specifically designed to feel urgent. If a court order is involved, that changes things the same way a warrant does with police, and asking to see it, reading it carefully, and understanding exactly what it authorizes before proceeding is the right move exactly as it would be with any other warrant. Let's talk about what happens when officers are already inside your home for an entirely separate, legitimate reason. You called them about something, they came to take a report about a matter that had nothing to do with you being any kind of suspect, and partway through the interaction, the conversation shifts. This happens. The nature of the conversation changes, questions start coming that feel directed at you rather than the situation you called about, and you start to feel less like a person who called for help, and more like a subject of something you didn't anticipate. The principles still apply even from this position. You can say, midway through an interaction that started on completely different terms, "I appreciate your help with this, but I'd like to stop answering questions now, and I'd prefer to have an attorney present before we go any further." You can withdraw consent for officers to remain in your home if they entered with your permission in the first place, though doing so in the middle of an already underway interaction is a more complex and delicate move than simply keeping them out from the beginning. The key point is that you are not locked into a path simply because an interaction started. You can change course, assert your rights, and decline to continue at any point. Let's talk about shared living situations, because landlords, roommates, and other people with access to your home each add their own layer of complexity that's worth understanding before any of it becomes relevant. The general principle is that someone with shared authority over a space can potentially consent to a search of that shared space. A roommate, for instance, can potentially consent to a search of common areas like a living room or kitchen, even if you personally don't agree. This consent authority generally does not extend to spaces that are clearly and exclusively yours, like a bedroom that is distinctly yours and that other occupants don't have access to, though the details here vary enough that it's worth knowing your specific situation, rather than assuming this bright line always applies clearly. A landlord is a different category. Despite the fact that a landlord owns the physical building and has a key to your unit, a landlord generally cannot consent to a search of a tenant's rented living space on the tenant's behalf, because the Fourth Amendment expectation of privacy belongs to the tenant, not the property owner, for the duration of the tenancy. If officers show up claiming they have consent from your landlord to enter your unit, that claim does not automatically create valid authority to enter, and stating that you do not consent to entry and that landlord consent is not the same as tenant consent is a completely appropriate response. Whether it stops the entry in that moment is a separate question, but it creates the record you need for what comes next. Let's talk about apartment buildings specifically, because multi-unit residential buildings have their own nuances worth understanding. The protection we've discussed throughout this entire video applies to your actual unit, your apartment, behind your own door. It generally does not apply in the same way to shared hallways, lobbies, stairwells, or other common areas that multiple tenants and the building itself have access to. Officers moving through a shared hallway to reach your door is not, by itself, a violation of your Fourth Amendment rights the way entering your actual apartment would be, because that shared hallway is not a space where you or any individual tenant holds an exclusive expectation of privacy. Your door, however, is the line. Everything on the other side of it gets the full protection we've been discussing. That line is real, and it is yours. Let's talk about code enforcement, municipal inspectors, and the various other kinds of official visitors that people sometimes group together with police without really examining whether the same rules apply. A city inspector showing up about a permit issue, a building code violation, a zoning matter. This is a category of official visit that works quite differently from a criminal law enforcement encounter, and understanding that difference protects you. In most circumstances, a municipal inspector does not have the authority to simply walk into your home without either your consent or some form of administrative warrant, which is a real legal tool, distinct from a criminal search warrant, but which still requires some form of judicial authorization in most contexts. You are not required to let someone into your home simply because they're carrying a clipboard with a city logo on it rather than a police badge. I'd like to understand the purpose of this visit and the legal basis for it, and I'd prefer to have my attorney involved before we proceed, is a reasonable, measured response that doesn't constitute obstruction and doesn't waive anything you'd rather keep. Let's talk about process servers in civil legal matters, because this is another category of knock at the door that's worth distinguishing clearly from what we've covered so far. A process server showing up to deliver a lawsuit, a subpoena, a divorce filing, or other civil legal documents is operating in a fundamentally different legal space from a criminal law enforcement encounter, and the tactical calculus is genuinely different here. Avoiding or refusing service typically doesn't prevent it from happening. In most places, process servers can complete service by other legal means once proper attempts at direct service have been made, and in some cases, service can be considered complete from the date of the first proper attempt, rather than the date you actually receive the documents. Refusing to open your door to a process server may delay your receipt of documents you legally need to respond to, potentially to your own significant disadvantage, rather than preventing you from being served at all. This isn't an area where the same calculus of rights preservation that applies to a police encounter maps cleanly, and understanding that distinction in advance helps you make a genuinely informed decision rather than applying a one-size framework that doesn't quite fit. Let's talk about the scenario that genuinely doesn't come up in most people's heads until they're already in the middle of it. What happens if you already opened the door before watching this video? Already let someone in? Already answered questions you now wish you hadn't? This is worth addressing directly and practically, rather than just noting that you should have done otherwise, because there are people watching this video right now who are in exactly that position, and they need to know what their options actually look like from here. First, and most importantly, don't try to retract or walk back specific statements in the middle of an ongoing encounter. Attempting to explain, revise, or contradict what you've already said in real time almost never improves your position, and frequently adds confusion, apparent inconsistency, or the appearance of ongoing deception on top of whatever was originally said. That is worse than the original statement in most cases. What you can do, even in the middle of an encounter that's already underway, is draw a clear, explicit line going forward. "I'd like to stop answering questions now," is a sentence you are allowed to say at any point in any interaction, regardless of how much has already happened before you said it. "I don't consent to anything further beyond this point," draws that line clearly and explicitly. You are not locked into continuing simply because you began. You can stop, and saying you're stopping, clearly and on the record, means the line exists from that point forward even if it didn't exist before. What comes after that line is what gets protected. What came before it is something to discuss, honestly and completely, with an attorney, in a private, protected setting, as soon as you can arrange it. Let's talk about preparing other people in your household for this scenario, because this is a dimension that almost nobody ever actually addresses, and it's a significant gap. Your rights at your front door only protect you as much as the person who answers that door understands and exercises them, and if someone else in your household, a spouse, a partner, a roommate, a teenager, a family member, anyone who might conceivably answer your door when you're not there, opens it and starts talking, without any of this framework in their head, the protections we've spent this entire video discussing can evaporate in a way that affects you directly, even though you weren't even home. Have this conversation, not as a crisis drill, not as something alarming, but as the kind of practical household information that matters in the same general category as knowing where the fire extinguisher is and what your insurance information looks like. What to do if someone official knocks at the door when you're not home. The basic questions to ask, the basic responses to give, the basic principles that mean you don't have to be a legal expert to handle the encounter without giving away what you'd prefer to keep. Don't open the door without asking if they have a warrant first, is something a teenager can understand and remember. You don't have to answer questions or let anyone in without a warrant, is something a roommate can hear and absorb in about 15 seconds. This conversation is short, it's practical, and it could matter more than almost anything else on this list. Let's talk about the difference between being polite and being compliant, because this thread runs through absolutely everything we've covered in this video, and it's worth pulling on it explicitly one more time before we close. Being polite means using a warm tone, treating the person you're speaking with as a human being, acknowledging their presence and their role without hostility, and generally conducting yourself in a way that keeps the interaction as calm and as low temperature as the situation allows. Being compliant means agreeing to things you're not required to agree to, opening doors you're not required to open, and answering questions you're not required to answer. These two things are not the same. They are not even on a spectrum together. You can be maximally polite and simultaneously decline absolutely everything you're not required to do, and doing so costs you nothing in terms of your legal position, while frequently making the actual encounter go more smoothly than it would if your refusals came with an edge. I really appreciate you stopping by, and I genuinely mean no disrespect, but I don't consent to you entering my home right now, and I'd prefer not to answer questions without having an attorney present first, is as warm a version of that sentence as you could possibly deliver, and it accomplishes everything the colder version does, without the unnecessary friction. There is no benefit to being hostile. There is significant potential benefit to being clear, consistent, firm, and genuinely polite throughout. Those qualities belong together in this specific situation more than almost any other one in your life, because what you're doing is asserting a right that is entirely yours to assert, in the one space where that right is at its absolute strongest, and there's no reason to do that in a way that makes the encounter harder than it needs to be. Let me give you specific, ready-to-use language for a range of different versions of this scenario, because I want you leaving this video with actual sentences, not just general concepts, because general concepts sometimes don't show up when you actually need them, and specific sentences do. If there's a knock and officers say they'd like to come in and talk, I appreciate you stopping by. I don't consent to you entering my home. If there's something specific you'd like to communicate, I'm happy to hear it through the door, or you can leave contact information and I'll follow up if needed. If they say it's just a few quick questions and it'll only take a minute, I understand. I'd still prefer not to answer questions right now. I'd want to have an attorney present for that kind of conversation. If they say declining to cooperate makes you look like you're hiding something, I hear you, and I understand that's how it might look. I'm still not going to consent to entry or answer questions right now. I appreciate you understanding. Ques. If they say they'll just come back with a warrant if you don't cooperate now, that's completely up to you, and I still don't consent to entry right now without one. And here's why that response is actually the right one, even though it feels like the losing position in the moment. If they can actually get a warrant, then there is a judge somewhere who is going to review whether there's actually probable cause justifying entry into your home, which is exactly the oversight the system is supposed to provide. If they can't get a warrant, that tells you something important about the legal footing they were standing on when they were asking you to voluntarily let them in. Either way, this outcome is better for you than simply opening the door to avoid the discomfort of saying no. If they present a document and claim it's a warrant, could you hold that up to the window so I can read it? Once you've seen it and identified what kind it is, if it's a valid search warrant for your address, I don't consent to this search, but I understand you have a warrant and I won't physically interfere with you executing it. If it appears to be an arrest warrant rather than a search warrant, I see this as an arrest warrant. I don't consent to a search of my home beyond what's required to locate the named individual." End quote. If something about the warrant looks wrong, this appears to be for a different address, or "I don't see a judge's signature on this," stated as an observation, not as an accusation. If they claim an emergency that justifies entry without a warrant, I don't consent to entry. I understand you may proceed anyway, but I'm stating clearly that I don't consent. Then don't physically interfere, and immediately document everything you can remember as soon as the encounter is over. If you want to end the conversation entirely, I don't have anything further I'd like to discuss right now. I'm going to step back from the door. If there's something you need to communicate formally, please leave contact information or reach out through official channels. And then you're done. These aren't magic phrases. They're not legal armor. They are, however, clear, calm, legally sound articulations of rights that belong to you, delivered in a way that preserves those rights while keeping the temperature of the encounter as low as possible. Let's talk about one more thing before we close, and it's something that sits underneath all of the practical information in this video, in a way that's worth surfacing directly. There is a reason this moment, the knock at the door after dark, the badge through the peephole, carries such a specific kind of weight, even for people who've done absolutely nothing wrong. Your home is where you are most fully yourself. It's where you're least on guard, least performing, least managing how you appear to the world. It is, in the most literal sense, the place you go to be away from everything external, including everything official and authoritative and evaluating. And an unexpected knock that places something official and authoritative right at the boundary of that space creates a psychological disruption that is genuinely uncomfortable in a way that has nothing to do with guilt or wrongdoing. It's the disruption of something that was supposed to be protected. The preparation we've walked through in this video is,
all right, that's where we'll leave it for today. I hope this gave you something genuinely useful, not just interesting to hear, but something you could actually use if the right situation ever came up. That's always the real goal here, understanding you can actually carry with you, not just information you forget by tomorrow. Take care of yourself, know what's actually yours, and I'll see you in the next one.